Hi everyone, my name's Hasti from Bayani Law, and we are trusted partners of the BII. And today we'll be looking at the Employment Rights Act 2025 and what these changes could potentially look like for you. So here's just a little bit about ourselves and what we do. So we provide employment law and HR support for businesses. And what we'll be covering today is the employment law roadmap. We'll be exploring 8 changes that are causing the most concern and looking at practical actions that you can take to protect your organisation. So the changes really started in December 2025 when we saw the repeal of the Strikes Minimum Service Levels Act 2023. And this was the start of a significant shift towards strengthening trade union rights. And this now means that there is no longer a legal minimum requirement for specific staffing levels to be maintained during industrial action. So February 2026, we saw the strengthening protection from dismissal for being involved in industrial action. And we also saw simplified ballot and notice rules for industrial action. There were some changes as well in April 2026, looking at a particularly significant milestone with several day one employment rights being introduced. So, this includes the right to take paternity leave and unpaid parental leave from day one of employment, as well as statutory sick pay being available from day one instead of day 3. And this will particularly benefit low paid workers. We also see a doubling of maximum collective redundancy protective awards, and finally, some menopause guidance being introduced initially on a voluntary basis in April 2026. This is reflecting a shift towards enhanced employee protections from the start of employment. Further changes in April 2026 are the launch of the Fair Work Agency to enforce labour standards. So that's looking at making sure that individuals are being paid correctly in terms of national living wage and minimum wage, as well as holiday entitlements. And later on, we'll be looking at holiday records as well. Simplified trade union recognition, reduced threshold for strike action. Sexual harassment will also now count as a whistleblowing qualifying disclosure, so that's now a protected act if someone was to complain of sexual harassment. Later on in the year, in the summer, we'll be looking at electronic and workplace balloting for industrial action ballots. October 2026, you'll see a continued theme of strengthened employee protections and expanded employer obligations. So from October 2026, there's a clear push to strengthen trade union access and influence. Employers will have a duty to inform workers of their right to join a union. Practically speaking, this means it needs to be referenced in the employment contract, and if they are already a part of your employment and they already have had their contract, potentially as an information sheet. There will also be enhanced rights and protections for trade union representatives, importantly, protections against detriment for taking industrial action, and that will be extended. In practice, this means employers will need to be more cautious in how they manage union related activities and how they communicate this information. Further changes in October 2026, we also see a significant strengthening of harassment protections. So, employers will be required to take all reasonable steps to prevent sexual harassment as opposed to reasonable steps. And we'll talk about this in a bit more detail later on. Liability will also extend to third party harassment, not just internal conduct. So, this could be looking at customers or individuals who might enter the premises for maintenance, for example. You'd also be liable for protecting your employees from them. Tribunal claim time limits will also be extended, and this is a key risk area. So, it's no longer policies alone, it would also be employers demonstrating active prevention. From January 2027, that should say, reduction of unfair dismissal qualifying periods from 2 years to 6 months, and that will be from the 1st of January. Removal of the cap of unfair dismissal compensation, that would again be from the 1st of January, and fire and rehire protections increasing. There are some more changes in 2027, so restrictions on 0 and low hour contracts. This will particularly be affecting the hospitality industry, as well as the right to reasonable notice of shifts being changed or cancelled. Equality action plans with introduction on a voluntary basis from April 2026. This will now become maybe more mandatory in 2027. So looking at them menopause guidance, for example, and new protections from dismissal for pregnant workers and those returning from maternity leave. More changes in 2027. We're looking at introduction of statutory bereavement leave for pregnancy loss before 24 weeks, and strengthening of flexible working rights, as well as changes to thresholds triggering collective redundancy consultation. And now just onto our final slide with the later changes coming into effect. At this point, we're seeing a shift from broad policy changes to more detailed regulation and enforcement. In 2027, we expect further clarification around what constitutes all reasonable steps in relation to the employer's duty to prevent sexual harassment, electronic and workplace balloting for recognition and derecognition on ballots. And there will be some changes with further regulatory measures. However, we're not quite sure on when these changes will come into effect, but it will be prohibition on non-disclosure agreements, also known as settlement agreements, concerning discrimination and harassment, holiday record keeping requirements to be enforced by the Fair Work Agency, and requirements to name providers of outsourced workers in gender pay gap reports. So we'll be looking at the 12 spotlight categories. Now, we won't be going into detail on all of these, but there will be a few that we'll be touching upon today. So for collective redundancies, this is important for hospitality businesses operating across multiple sites or managing large-scale restructures. So employers may face broader obligations to collectively consult when making redundancies across the business and not necessarily just in one location. So that means if you have several pubs, for example, or if you have multiple restaurant locations or venues, the redundancies or restructures taking place in all of these locations would be counted together when looking at the consultation, limitations and for consultation purposes. Multi-site operators will need to take a more joined-up approach when planning staffing reductions, and failing to follow the correct consultation process could lead to increased tribunal risk and compensation risk. As we can see, the compensation risk has doubled. So from instead of the 90 days protective award being awarded to individuals who bring a claim, it's now 180 days per employee. And so if you fail to consult properly, there are major cost implications to this. So creating a centralized system to track proposed redundancies. You'll have to also look at refreshing manager training as well as strengthening relationships with employee representatives to support the consultation process. So these are just a few steps that you can take to reduce organizational risk as well as effective planning of redundancy processes. In March 2026, there were a few last-minute changes added to the Employment Rights Act, and this is one of them. So holiday records. At the moment, employers only have to make sure that employees have the right to take holiday leave. However, from April 2026, the obligation also passed to employers, making sure that they're keeping adequate records of annual leave being taken, leave carried over, holiday pay calculations, payments in lieu of untaken leave, and not just necessarily making sure that the adequate records are being kept, but that these records are clear and accurate as well as easily accessible. They must also be retained for 6 years, which align with broader employment and payroll record keeping obligations. So, how can you reduce organizational risks when looking at holiday record keeping? So, it's not just necessarily a paperwork exercise. There is a real legal and financial risk here, because failure to keep these adequate records will be a criminal offence. So it's important that you review how the holiday is tracked, potentially move away from spreadsheets to people management systems instead, making sure HR and payroll are aligned, and improve record keeping retention as well as checking holiday calculations. Employment tribunal time limits will now be increasing. So currently, most claims such as unfair dismissal must be brought within 3 months less 1 day of the relevant act taking effect. So for unfair dismissal, from the effective date of termination. But under the proposed reforms, this time limit will be extended to 6 months. For claimant representatives, this could be seen as a beneficial for individuals, as it gives employees more time to seek advice and bring claims, which also shows how important it is to make sure that you have these clear records that are being kept, because the claims can land on your desk much later. So if you can demonstrate that you have all of the relevant information available, it'll be much easier to defend the claim. So how can you reduce your organizational risk? So ensuring that managers record carefully their reasonings for dismissal or any other relevant decision, and keeping their notes. Getting into the habit of taking statements from key witnesses at an early stage once you receive a claim, so that it might still be fresh in their memory. Training managers on what good documentation looks like, and creating an internal process that helps to respond to claims quickly and consistently. So for unfair dismissal, employees need 2 years of service to claim for unfair dismissal at the moment. And so that effectively means there is relatively limited protection in the first 2 years, which means if you were to dismiss them, they wouldn't be able to bring that unfair dismissal claim unless it's an automatically unfair reason or there's potential discrimination, which doesn't have a time limit. Once that 2-year threshold is met, employers must be able to demonstrate a fair process as well as fair reasoning. What's changing from January 2027 is that 2-year qualifying period is being reduced to 6 months. So that 2-year window that you now had to be able to see whether or not they were the right fit for you or not, potentially, is now being reduced to 6 months. So that means that it's a really, really important that the way that you hire and retain staff, or probation reviews, for example, are being done correctly. There's also going to be a removal of the cap on unfair dismissal compensation. So at the moment, the compensation is capped at 52 weeks of pay, or £118,223, dependent on which is lower. Now that's going to be removed, similar to discrimination claims, so more financial risk moving forward. So recommendations on what you can do to prevent or reduce organisational risk is reviewing your recruitment and selection processes to reduce number of poor hires being made, ensuring organisations have effective induction and probation policies and processes in place, managing probationary periods closely and communicating effectively, being honest, being transparent, being consistent, and remembering there is no length of service requirement for discrimination claims. So although you have that protection, I suppose, with unfair dismissal, discrimination is a day one right. So looking at family-friendly reforms, parents are entitled to statutory maternity, paternity, shared parental, adoption pay and leave, plus unpaid parental leave. So that's the current situation at the moment. Statutory paternity leave requires 26 weeks service, and unpaid parental leave requires 12 months service. Statutory shared parental leave has to be taken after paternity leave. If it is taken beforehand, the opportunity to take paternity leave is lost. And what is changing is that statutory paternity leave and unpaid parental leave will become a day one right, and this will bring them into line with other family leave entitlements. The government has done this to expand the rights for fathers to be there, but also looking at whether they will be able to extend the paternity leave from 2 weeks to 6 weeks. So it's something to keep your eye out for. Shared parental leave will be able to be taken before or after paternity leave, and the idea behind this is to provide more flexibility for employees to take the type of leave that best suits them and their child. So to how to reduce organisational risks, employers should be updating their internal policies to reflect this change and ensure that managers are aware of the new eligibility criteria. This may involve revising employee handbooks, training HR staff, and communicating the changes to employees. Fire and rehire. So employers can dismiss employees if they have not been able to reach an agreement on changes to terms and conditions at the moment, subject to following a fair process. But as of January 2027, there will be stronger protections for employees. So employers will face tighter rules around dismissing staff and rehiring them on maybe less favourable terms. And the aim is to prevent businesses from using dismissal as a way to force through changes to pay, hours, or benefits. This could impact the hospitality operators. Often because you often need the flexibility to respond to rising costs or changing in trading conditions, or even changes around demand. So this is just something that you need to be taking into consideration and trying to reduce your organizational risk. So what you can do is audit your contracts of employment and identify outdated clauses or areas of ambiguity. Strengthen consultation processes, build a clear framework, review your business strategy, and assess if your terms and conditions support goals. Where needed, build robust business cases for change and strengthen employee communication. So 0-hour and low-hour contracts expected in 2027, a key change for the hospitality area. Again, this is because pubs, bars, and hospitality venues mainly impact rota planning and casual staffing arrangements. So workers who regularly work consistent hours may gain the right to a contract reflecting their actual working pattern, as opposed to what is necessarily useful for the business. Long-term casual staff who have consistently worked high hours may need to be moved onto a guaranteed hours contract. So for example, if you've had a 0-hours contract regularly working 30 hours a week, they could become entitled to having a guaranteed 30 hours contract. And so employers will be expected to give reasonable notice as well to shift changes, as well as any rota changes, and you may need to pay them if the changes are quite last minute. So you might need to publish your rotas a lot earlier and reduce last minute scheduling where possible. If shifts are cancelled or reduced at a short notice, as I said, there could be some compensation payable. We're not quite sure on what that compensation looks like at the moment, but we will be finding out later on in the year. And the overall aim is to provide workers with greater predictability and income security. Flexible working arrangements. So employees will have increased protections when requesting flexible working arrangements, and employers will need clear business reasons if a request cannot be accommodated. Requests may include changes to working hours, shift patterns, or working days. For pubs, bars, and hospitality venues, this could affect rota planning, peak trading coverage, and team availability. Managers should ensure requests are handled consistently and fairly, and clear policies, good communication, and proper documentation will help reduce disputes and demonstrate compliance. So these changes are aimed at encouraging employers to accept requests, although details of how this is going to happen is still in consultation. But we expect regulations on specific consultation processes. Refusals must be reasonable, and employers must show that the reason for refusal is genuine and evidence-based. So how you can maybe minimize these risks in your organization is to understand your organization's policy and amend if necessary. Really think about the request and get objective data to support your decision. Ensure you present all the information to the employee and give them the opportunity to request, to ask questions before refusing, and consider appeals objectively. For harassment, having a clear and regular updated policy specifically dealing with sexual harassment, providing mandatory training for all staff on what sexual harassment and what amounts to sexual harassment and the standards of behaviour expected from the staff, and how to raise a complaint and additional training for managers on how to handle a sexual harassment complaint. Having a zero tolerance workplace culture in relation to sexual harassment, which is openly supported by senior management so that individuals feel comfortable enough to come forward if this was to happen. So encouraging the reporting of sexual harassment by providing different methods of doing so, and clear processes for investigations and complaints to be dealt with. So it's making sure that you have taken all reasonable steps, although we're not quite sure what all is defined by, but making sure that you're doing everything that you can so that your employees are feeling protected and safe. Reducing organisational risk, so reviewing sexual harassment risk assessments to ensure all key steps are being followed. This must include the management of third parties. So potentially you could put signs up that you don't tolerate harassment within your vicinity or within your venues. Ensure policies are up to date, ensuring all workers receive training with managers to be provided with more in-depth support, all training to be regularly refreshed. So SSP changes, and so this is a big one, again, for the hospitality organisations, because SSP is currently being paid from the 4th day of sickness. So you'd have 3 days of unpaid sickness, and then as of day 4, you'd be paid. However, now employees will be allowed to be paid for SSP as of day 1, as well as lowering earnings, as well as the lower earnings limit being removed. So initially there was a cap for the lower earnings limit, but that is going to be removed. So employers will be required under the ERA to pay SSP from day 1 of sickness, and this is something that you'll be seeing happening maybe more often, especially if someone is maybe on a lower wage. They might feel a bit more comfortable now going off sick because they'll receive that pay from day 1. Reducing organisational risk, so conduct forecasting to assess cost impact of SSP changes, updating sickness policies to ensure changes have been reflected, and ensuring absences are being managed effectively to stop sick pay costs escalating. So how potentially we can help you moving forward. So we can help you prepare for the Employment Rights Act. We have an ERA page on our website with lots of information on there, as well as up to date, and it will be kept up to date if any new changes come into effect. And I would recommend scanning the QR code, which you can then download the planner to keep track of any changes. So there's lots of free resources on there that you can take advantage of. We also provide training for managers. If you are wanting to take a look into that, please do get in touch. You can do so by contacting us on the email below at hello@bayanilaw.co.uk, and we'll be able to look at how we can support you and your management team. And thank you so much for watching today's webinar.